Okay, so I'm happy to introduce you to today's speaker, Glenn Cantor. In 1986, Glenn was a recent graduate of USC Law School and accepted his first job as a lawyer at a large downtown Los Angeles law firm. He was assigned to represent health, life, and disability insurance companies who were being sued for denying insurance claims. Ultimately, defending insurance company denials was not Glenn's idea of pursuing justice. So in 1992, Glenn created a law firm which exclusively represent insureds whose claims had been denied. Meanwhile, Lisa Cantor, Glenn's wife, had created a stellar reputation as an appellate law expert. In 2004, Glenn and Lisa created Cantor and Cantor LLP, a law firm specializing in representing individuals whose health, disability, and life insurance claims have been wrongly denied. In the past 20 years, Glenn has represented thousands of individuals suffering a wide range of medical conditions. Glenn also represents family members to obtain wrongfully withheld life insurance benefits in situations regarding DUI deaths, domestic partnerships, failure to disclose, and improper enrollment. He works with elderly clients to help them obtain long-term care benefits that they are entitled to under long-term care insurance policies. So thank you so much for joining us today, Glenn, and I will give you control.
Okay, good morning or good afternoon, depending upon where you are listening to me from. Nicole giving me control is not seeming to work. How do I move to the next slide?
Are you able to click and it will move? It's showing that you have control.
No, although I'm not sure where I'm clicking, but
1 second.
I don't know if I did that or you did that, but let's start. Okay. Unfortunately, life, is that you or me doing that?
Give me 1 second. All right, are we good now?
We're good now. Okay. Unfortunately, life deals us hard breaks at times, and obviously getting cancer is one of them. What we should not have to be dealing with is the loss of income, which will often go along with a cancer diagnosis. Either the treatment, cancer itself, or the after effects of the treatment can prevent one from working. And often individuals have short or long-term disability benefits provided through their employer, which will provide them with funds to live on while they are receiving treatment and recovering. And that's what I wanted to talk about this morning or this afternoon. And okay. Having cancer by itself will not afford anyone the right to recover either short or long-term disability benefits. They will have to demonstrate an inability to perform their work. Obviously, the seriousness of the cancer is one factor. Not to downgrade, but an early stage of skin cancer is probably not going to disable anybody. Obviously, something like pancreatic cancer is the opposite. So the first thing we would be looking at is the type of cancer and how serious it is. We would be advising people they have to, have their doctors assess them and provide information that the treatment or the side effects of the treatment or the cancer itself are causing occupational difficulties, would prevent someone from working. So the other thing we'd be looking at, or another thing, is what somebody's demands are, their personal demands of their job. Demands are usually categorized as sedentary, light, medium, and heavy, and those come into play when determining if you are disabled. Also, what comes into play in a long-term disability policy are the policy provisions, particularly the definitions of what constitutes disability, which I will be discussing. Okay. All right, Nicole, I'm not able to move to the next. Maybe you'll just have to move as I tell you. Okay, so you will have specialists, obviously, who are treating your condition, and you'll need to talk to them about obtaining assistance to submit benefits. Next. Okay. Obviously, you'll want to demonstrate to the insurance carrier that you are receiving treatment. Okay. We'd like to tell our clients not to be martyrs. When you are talking to your doctor, don't go in and say, I'm fine, I'm doing great. You need to be telling people exactly what's going on and documenting your symptoms, because it's the symptoms which are going to be the basis of a disability claim. If you are having medication reactions or you're having side effects from chemo, you need to be documenting them. Okay. Next. Okay. There are a number of different things about cancer which can disable you. It can cause severe pain. Pain in itself can be disabling. The treatment of the cancer, the medications can be severely disabling. They can cause cognitive decline. The fact of the depression or the treatment, the fact of the condition or the treatment can cause depression, which can be disabling. The treatment often causes severe fatigue, and that fact can cause disability. These are things you have to be documenting. You may have neurological changes which affect body movement and bowel and bladder issues, which can prevent, especially if somebody is, has a job that requires them to drive or requires them to be out in the field, that could be a disabling symptom. So these are the kind of things you have to make sure to be talking to your doctor about, because it's the doctor's records which are going to support your disability. Next. Okay. As I said, you want to be documenting this to the best of your ability and telling your clients, if you're social workers, to be documented. You may be needing to get support. The doctors are not going to see you as often as your friends and colleagues or relatives are, and you can get statements from them about their observations, that you're usually an early riser, but now you can't get out of bed until noon. Or if you go for a walk for half a mile, you are limited to a chair for the next 3 hours. And of course, as I said, reports from the doctors about your condition are going to be essential. So, make your appointments, and when you do, you want to be documenting all of your symptoms. You'll need to be gathering medical records, because the long-term disability carriers are going to want more than just your statements or your doctor's statements. They're going to want to see it documented. There are things that we see that you're going to need to explain. For example, if somebody is diagnosed with mild cognitive impairment, people think, well, I guess maybe I'm okay to work. And insurance companies will often say, well, it's only mild. It's not really a problem. In the world of cognitive evaluations, the next step above a mild impairment is a severe impairment where somebody is not safe to be left alone. They can't handle their own activities of daily living, such as bathing or using the restroom without assistance. So mild is very disabling from an employment point of view. If you have a Social Security decision which determines that you are indeed disabled, that's something you need to assemble so that you can provide it to an insurance carrier. Even if the insurance carrier wants to say it's not good enough for them, if you end up in court down the road, which hopefully you won't, courts are particularly impressed with Social Security decisions because they know how difficult it is to be awarded Social Security disability. Next. Okay. Once again, what evidence do I have to support my claim? You'll want all of your doctor's records, which are pretty easy to get. Your doctor will be asked to support you. most, no, I shouldn't say most, we get all kinds of situations with doctors. Some are very supportive and are willing to take the time to do what is necessary to document your situation. Others, while being very supportive, won't take the time. You may have to actually pay them to take time out of their day or after their day to write a letter. And sometimes we even have to send our clients to a separate doctor to document disability because the treating doctor just will not cooperate. As I mentioned before, there are different kinds of jobs. When you're making claims, you want to be telling the insurance company what your job duties are. If you are traveling, if you need to do heavy work, if you have a job requiring a high level of cognitive skills, and you're having problems, those are the kind of things you need to document and make sure the insurance company is aware of. Also, if your employer is recognizing that the impact of your cancer or treatment is impacting your job performance, and they are downgrading that when you've had, let's just say 10 years of great performance reviews, and now, they may hopefully are kind, but they're saying, you're not getting the job done. Maybe you need to be on disability. Those are also things which are very, very impactful to insurance companies. Next. Okay, and it's helpful when we are making claims to keep a journal of your symptoms. That is also impactful to insurance companies. Social media. If you're feeling good one day and you decide to take a walk to the beach or take a hike, and the insurance company sees it, and I assure you they will be looking if they can, they will use that information on your social media to suggest that you are exaggerating your symptoms. And if your friends can see your post, so can they. And if your friends are tagging you on their post, the insurance companies can often use private investigators to follow you around in that methodology. Statements from supervisors, coworkers, subordinates, caretakers, family and friends about your symptomology are the kinds of evidence which will impact an insurance company and will also impact, if necessary, a judge down the road. And as I mentioned before, so will the Social Security Award. Next. Okay. The insurance company, if they question the extent of your disability, might send you to what they will call an independent medical examination. As I'll discuss in a few minutes, they are rarely truly independent. They're often, and I hate to be pejorative, but we sometimes call them liars for hire. They're doctors who are willing to say what an insurance company wants because they're being paid. If an insurance company ever tries to send you or your client to an independent medical exam, you need to make sure that that doctor is a board certified oncologist, because anybody who is board certified oncologist is going to know the impact of cancer and its side effects and is much more likely to be honest. And if you are sent to one, you get a negative report with regard to your ability to work, we would sometimes send one to our own to get a truly independent viewpoint. Next. Okay, there are different kinds of coverage. Short term is typically for 90 days to 6 months, and is meant for somebody maybe who has a broken leg, can't work, and is going to be out for a short period of time. Carriers are typically pretty generous in awarding those benefits because they're not looking at a huge financial liability. Also, some states, California is one, provide state short-term disability, which lasts for a year. Not many states have it. Long-term disability, which is what we're really here to talk about, is typically provided by employers to their employees, and it is intended to provide income replacement if you're going to be out of work due to a disability for a long period of time, typically more than 6 months. The vast majority of group policies issued to employers are covered by a federal law called ERISA, which I'll discuss in depth. The only exception is if your employer is a governmental entity of any type, which would include public school teachers, anybody who's actually a government worker. It can be a wide net. People who are government workers or people who work for a church entity, which could even include a hospital, which is church owned, could be exempt from ERISA, and then you're going to be governed by state law. And as I'll discuss, that could be a good thing, it could be a bad thing. Also, people may have purchased individual policies separate from their employers, and those policies, which we call individual policies, are totally different. Social Security disability is something that people pay into. The vast majority of us do. And if you're going to be out of work for what's expected to be at least a year, you can and should make a Social Security claim. I'm not here to talk about that, and that's a long discussion, which would take a great deal of time, but something you need to be aware of and talk to somebody about. Next. Okay. So, as I said, there are a few states that have state mandated benefits. California, Hawaii, New Jersey will provide short-term disability. And if you have a diagnosis of cancer and you're in treatment, it's almost going to be automatically granted. A lot of large employers have either short-term disability policies or they just have a policy themselves where they will pay your salary for some period of time while you're disabled. They will not take your word for it. They will have what's called a third-party administrator that almost acts as a quasi-insurance company to review the claim, and you'd be submitting your claim to them. Then there's the short-term insurance, which is a policy provided by your employer, purchased from an insurance company, and they will look at your claim and determine if you are disabled. Unfortunately, what we often see is short-term disability carriers who then become the long-term disability carriers, and they will sometimes terminate a short-term disability claim 3 to 4 weeks, maybe even shorter, before you become eligible for long-term. The reason for that is if they pay the full short-term benefit, which is often employer funded, and the next day it's going to go to long-term, which they fund, it's hard for them to terminate at the switch from short-term to long-term without some reason, some change in a condition, and so they try to do it in advance. Next. Okay, this is what we're really here to talk about, is group long-term disability. Most large employers and many smaller employers will provide long-term disability to its employees. Either they automatically provide it and they pay for it, or they give you or their employees the option to pay for it. The benefits typically provide somewhere between 50 to 66% of your pre-disability income. And with the way these policies are set up is that the insurance company, they're not promising to pay you that amount of money. What they are promising is if you are disabled, you will receive that amount of money from all sources, and they are the last source, which is really important because they're going to want people who they are insuring who become disabled to apply for all other benefits to which they're eligible. For example, if somebody's receiving $5,000 a month from an insurance company in disability benefits, but they get $2,000 from Social Security and possibly another $1,000 for their children, the insurance company will first take that $3,000 and say, all right, there's your first $3,000. We'll make up the difference, which is only $2,000. It makes a huge difference to the insurance company, which is also why if you are getting Social Security, it's difficult for the insurance company, on the one hand, to claim that they get to take the offset, but then to deny that you're disabled when Social Security says that you are. Next, please. Okay, I talked a minute about Social Security. Social Security is a high bar. It's there if you're not able to work in any substantial gainful activity. It does, while the insurance company will offset what you get, there are benefits of having Social Security, even if the insurance company uses it to their benefit more than yours. In these days of high inflation, they provide cost of living increases, which are not offset by insurance companies. Once you're receiving Social Security benefits for 24 months, you get Medicare, which is obviously a very important thing. If you're receiving Social Security, you can freeze your retirement benefit so that if you haven't worked as many years as you need to, that you'll still qualify under a pension plan. Under the law, while insurance companies may attempt to ignore Social Security decisions by saying it's a different standard, in reality, if it gets to court, they're not able to, because judges understand that it's a much higher standard, and they will look very closely at an insurance company who rejects a Social Security decision in order to try and deny a claim. Go ahead, next. Okay, what is ERISA? You may hear that term. ERISA stands for the Employee Retirement Income Security Act of 1974. I could take a great deal of time to explain it, but unfortunately, the way it's been interpreted by many courts is, while it stands for the Employee Security Act, the courts have implemented it in a way that sometimes is more of an insurance company protection act. When the statute was passed, it required that if an insurance company denied your claim, they had to give you a right to ask them to reconsider the denial. The law has been interpreted such that if you don't appeal, you can't sue. And if you don't appeal timely, you can never sue. And that's really important. If you are denied, they have to give you a copy of your claim file to review to determine how to prepare your appeal or how to bring it to a lawyer. If you ever are terminated or denied, the first thing you do is to get that claim file. Any lawyer who does ERISA work can help you do it. The appeal process is extraordinarily important because the law has also been interpreted that only the information that you include, and I'm sorry, my phone is ringing, that you include in that appeal will be considered by a judge if it gets to court. So you can't just write to the insurance company and say, well, you're wrong, I'm right, I appeal, and then wait and go to court. You have to make sure that every piece of evidence which could support your claim has been given to the insurance company or your employer's benefit plan before you bring suit. All right. The last bullet point, and I don't have a great deal of time to explain all this, but that insurers in some states, about half the states, are given a great deal of leeway in deciding the merits of a claim. They're given what's called deference. In other states, based on state law, they're not allowed to have that deference. California would be one state where they're not entitled to that deference. But under ERISA, you can't think a jury would decide with me. You do not get a jury. You don't even get to be a witness at your own case. A federal judge will decide your case, and the judge will decide it not based on your credibility or the credibility of the insurance company's witness, but rather on the contents of what is in that appeal file that the insurance company and you or your client created, hopefully with the assistance of an attorney. Next. Okay, if you do need to get an attorney, you may think, I don't have the money to pay an attorney. The vast majority of attorneys who handle these, for example, my firm, handle them on a contingency basis. We handle these cases 99% on contingency. We only take fees if we are successful in obtaining benefits for you. And we recognize the people who aren't working can't pay us up front. So we take cases when we think that we can win them and that we'll get paid out of the benefits. I mentioned before that benefits are offset by other things, workers' compensation, which typically you're not going to get if it's cancer unless you can demonstrate that the cancer was caused by your work, but Social Security and other kind of disability benefits. We as a firm only take fees on the money we get from the insurance company. If you were to go to a lawyer and he says, no, I take fees on everything, whether or not I get it for you or not, my quick advice is find a different lawyer. Now, there are different kinds of coverages, as I said. You can get coverage under ERISA, which is an employer-provided policy, which is provided, and I'm sorry. I'm sorry. Anyway, the ERISA plans, as I said, the benefit is based on what you were earning before you became disabled. Typically, if you're commission-based and the employer knows it, they'll have a policy which includes commissions. If it's not commission-based, then things like small commissions or bonuses won't be included. When you go to work for an employer, if you accept the insurance, if you have to pay for it, or it's given to you without you having to pay for it, it's not individually underwritten, which means if you've had cancer previously, they cannot deny you. And if you work for more than 24 months, they can't deny you if you've had a pre-existing condition. Once again, I mentioned before, there's no jury. This will be decided by a judge. ERISA coverage, because it's provided to groups, is much, much cheaper for an employer to purchase for its employees than an individual policy, which is why the vast majority of individuals who have disability coverage get it through their employers, and it's not individually purchased. In my experience, it's doctors, lawyers, and other very high income earners who go out and purchase individual. Most people who have it through their employers. The biggest single disadvantage of ERISA plans are that under the federal law, the insurance companies have been given just free rein to deny claims because there are very little in the way of remedies. The most a court can ever do to an insurance company who wrongly denies a claim is to make them pay it and maybe pay attorney's fees. So unfortunately, I see just some incredibly shocking denials of disability claims. I'll stop for a second and see. I don't see that many shocking denials in the cancer context. It's rare, but I have seen them. I once had a client with stage 4 pancreatic cancer who'd had a Whipple procedure, and within a week of the procedure, the carrier said, well, you can go back to work. Of course, we won that claim, and that is unusual, but it does happen. Now, the advantages of individual coverage, which most people are not going to have, it's for a specific amount that you choose, but you have to have been individually underwritten, which means they will look at your medical history. If you've had cancer, it's unlikely they're going to give it to you. It's much more expensive. You pay the premiums yourself. But in many states, including California, where I am based, if an insurance company unreasonably denies a disability claim, you can bring a case in the courts. You don't have to appeal, and you can receive remedies beyond the benefits which you're owed, including attorney's fees, emotional stress damages, and if the denial is outrageous enough, a jury, and in individual cases, you do get a jury as well as witnesses. The court can award punitive damages, which are not intended to compensate the insured, but rather to punish the insurance company so they don't act in bad faith towards other insureds. Next. Okay. Very few people ever look at their disability policies until they need to make a claim, and then they look at them. And it is important to read the provisions. Most group disability policies have limitations for certain kind of conditions. I have never in 38 years of doing this seen a condition or a limited condition related to cancer. However, almost all policies do have limitations for mental and nervous conditions. You never want to be in the position of having the insurance company say, well, it's not your cancer that's disabling you. It's not even the side effects. It's that you're depressed about even having had cancer or fear of getting it again. So that what you're really disabled by is a mental condition, and that only pays for 2 years. So if you continue with the traps, that's what I'm going to talk about. So you'll read your policy. Without it, you just don't know what you have to do. Some policies will provide you benefits if you're unable to perform the normal duties of your own occupation, but after 2 years, many say we'll only pay you if you can't do the duties of any occupation. Okay. Insurance companies will try and pigeonhole you and say, well, even if you were let's say, a college professor under your own occupation, you could now go and be a video surveillance monitor, just watching to see security tape at a building. In many states, they will not allow that. They have a provision called Station in Life, which requires that any occupation position they say you can do has to be something similar to what you were doing. They might say that an RN who can't work in a hospital can review medical records and write reports, but they couldn't say to a college professor, you can now be a greeter at Walmart. Not to, say anything bad about greeters at Walmart. We all have a place, but there is a Station in Life requirement. Go ahead. Okay. The insurance companies over the years continually put in provisions to try and limit their obligations. One is that you have to have objective evidence of a disabling symptom. The fact that you have cancer does not in itself say that you're disabled. They want to see objective evidence of disability. Now, if your disability is pain, it is impossible to quantify pain. So what we argue typically successfully is if the kind of cancer you have typically leads to a great deal of pain and you're credible in your reporting, that is typically sufficient. If you're claiming cognitive deficits or fatigue, there are objective tests for both of those. For cognitive deficits, there are neuropsychological tests which will demonstrate that somebody has a decline. For fatigue, there are cardiopulmonary exertional tests which will show that someone has a level of fatigue which is far beyond normal and that they cannot work. Those are the kind of things that we do, or you should do on your own, to provide testing to insurance companies to make it difficult for them to deny claims. Okay. Once again, in my experience, and there's exceptions to every rule, insurance companies typically pay cancer claims, but there may become a time when they say you should have recovered. Yes, you had breast cancer. Yes, you had prostate cancer, but the treatment is over and you should go back to work. You may have impairing symptoms and they'll disagree. They'll send you off to what I've nicely called it an IME, independent medical exam. We call them insurance medical exams because they're typically not independent. Our advice is bring a friend with you to observe, take notes. If the doctor says he examined you or talked to you for an hour, it was actually 5 minutes, you want to be able to document that. Another thing to watch out for is if you're complaining of pain, if you're complaining of an inability to walk without assistance, you can expect that on the day they send you to that exam, they may have a private investigator conducting surveillance. We've seen situations where somebody walks out of their home twirling a cane on their arm and stops using it when they get within 20 feet of the doctor's office. That, for obvious reasons, is very harmful to a successful disability claim, but somebody who's doing that probably doesn't deserve it anyway. But it is important to understand that they will try and catch you on your good days with surveillance. If they send you to an IME, you want to make sure that you have your records to give to them so the doctor can't say, I didn't see any records. Make sure that you have it to give to the doctor. Now, you can ask for a copy of the report or have it sent to your doctor. If they're going to deny your claim after that IME, they have to give it to you. If they decide to pay your claim, hopefully that's what happens, they are not obligated to give you a copy of the report, and frequently they won't. Next. Okay. When you submit an insurance claim, or you are in the midst of one, you will often get phone calls from the insurance company to talk to you about your situation. My advice is do your best to avoid those phone calls. We advise that everything be done in writing, but if you do have conversations, take notes to make sure you know what they said and you know what you said, and try and get the name of the person you spoke to. If they say, hi, I'm, Hannah S. from Hartford, ask for the last name so you know who it is you were talking to. If they ask you to send things into them, make sure you send them via certified mail. If it only goes to a post office box or FedEx or UPS, so you have a record that they received it. We often hear from companies, well, we never saw that. We didn't get a copy of it. But if you have the certified mail green card to say, well, someone in your mailroom signed for it, then you've got evidence that they, in fact, received it and either lost it or threw it away, which, believe it or not, we do see happen. And keep copies of whatever you send into the insurance company. Next. Okay, if you are denied after you've made a claim to your employer's group policy, there are 3 things that are really critical. First is that you're entitled to your claim file. Sometimes it's called an administrative record, and you need to get that before you appeal, because in order to appeal, you have to know their reasons for the denial, and those are typically included within the claim file. As I said before, the appeals are mandatory. Don't let anyone tell you otherwise. Not a lawyer who's not an ERISA specialist. Just believe it. You have to do it. And as I said before, in order to be successful, your best chance are with a competent ERISA lawyer, not a general practitioner, because they're not going to know what to do. And as I said, only the information included in the appeal is going to be considered by a court. I've had clients come to me and said, my brother-in-law did my appeal, and he said he kept out the most crucial, the best piece of evidence to use as a smoking gun in court. Well, you may want to be then suing your brother-in-law for malpractice, because if you didn't put it in during the appeal process, it likely won't come in. The rules have changed. The Department of Labor has made things more favorable. This is really important. You get the last word, use it. If the last thing the insurance company gives you is a report from some doctor saying why he thinks you're not disabled, you get the right to have your doctor rebut it, or you can rebut it yourself. But the point of it is, you get the last word. It's critical to use it. As I said, I've been doing this for a very long time, and my theory is, and I think it's backed up, that the insurance companies, they have computers and they do studies, and they know that if they get, I'm going to call them 100 legitimate claims, and they deny them all, some percentage of people, maybe 30, are just going to give up and go away. They've then won 30 claims. If 70 people appeal and they deny them all, maybe only 30 people will file lawsuits. They've then won another 40 claims. Of those 30 lawsuits, maybe they'll win 10, they'll lose 10, and they'll settle 10. The point of it is, in general, if they paid that 100 legitimate claims, it might cost them $30 million. But if they take a position of deny, they may pay not 10 million if they paid them all, but maybe 2 million. Now, I do want to stop for just a second and say that, as I said, I've seen and handled thousands of insurance company denials. Maybe 1% of those involve cancer. And I don't see the thousands and thousands of claims that are paid. Nobody's ever walked into my office and said, I made a claim, they paid it. Will you sue them? So I'm not seeing the good things insurance companies do. So I don't want to completely denigrate them. There are some good insurance companies out there. There are good people working at them. And sometimes they're going to do their best to find a way to pay your claim. Okay. So don't be overly discouraged because you're talking to a lawyer who deals with denials, not approvals. All right. What is the claim file that you need to get if you do make a claim and it's denied? And I want to stop. The only way you get it is if you are denied or they make what's called an adverse benefit decision. If they approve your claim, but say we're paying it because we think you have a mental disorder, you're depressed, that is an adverse claim decision if you are making a claim for physical disability under cancer. So that is what we would call an adverse claim decision. So you're entitled to the claim file. And that claim file consists of just anything that the insurance company considered, anything they should have considered, any policy or guideline they have regarding your claim. They have to provide you a copy with it. Okay, and they have to do it free of charge. All you have to do is write to them and they have to give it to you within 30 days. Okay, this is a complicated legal context or a doctrine, which I was talking about, is that when a court reviews the claim denial, if it gets that far, half the states will allow the court to give discretion or deference to the insurance company under the theory that the insurance company has no reason to improperly deny your claim. Frankly, it's one of the stupidest decisions that the Supreme Court has ever made on the theory that they may not have a reason to deny one claim. One claim is not going to impact their bottom line, but they are denying thousands of claims and they have a financial reason to do it. So giving discretion to an insurance company it's just a horrible thing to do. 12 years ago, myself and colleagues got up to Sacramento, where the capital of California is, and we pounded on the table enough that California said no insurance company who does business in this state can sell a policy which gives discretion to an insurance company. I would recommend to all of you out there who are in a state that does allow discretion, and you can Google it and find out, to call your congressperson. At the moment, there happens to be a bill which is before both houses of Congress to ban discretion in any policy that's governed by ERISA. And it's gathering some level of bipartisan support. The election is, well, mostly over, and congressmen may be in a mood to go ahead and sign this. And somebody said there's a takeaway is to move to California. Well, I don't know where you are today, but it's about 75 degrees and beautiful here. But California does provide more protection to its consumers than any other state. I will say that. Next. Okay. Once again, you may not, if you have a claim for disability benefits for a policy governed by ERISA and it's denied, for the most part, under no circumstances can you bring a lawsuit if you haven't appealed. You can do it on your own. And I have sometimes told people, you can do this on your own. There is no way that they can deny it. And if they do, I can take your claim and I'll win it in court. I say that 1 out of 100 times because for the most part, a law firm who knows what they're doing is going to do it better than you. I realize you will have to pay the law firm, but as I tell people, 80% of something is better than 100% of nothing. A law firm that focuses its practice on ERISA claims is going to know how to build that record so that you win in court. If you do it on your own, though, you want to tell them every possible reason why you're entitled to benefits. If they have utilized a doctor who's not an oncologist to say, well, you shouldn't be having these symptoms. If there are reasons for denying a change, if they don't accurately look at your job description, or they're misstating your job description, or you haven't given them a full job description. These are the kind of things you want to point out in an appeal. Now, I do have limited time, and it would take an hour to properly explain how to do an appeal. The best advice I can give you is get a lawyer to help you. If you don't get a lawyer, get your doctor. Doctors writing exhaustive letters are the best sort of evidence you can. If that doesn't work, demand the insurance company send you to an IME with a board certified oncologist. They may say, no, we don't think we need it. But if you ask and they say no, and this goes to a judge, the judge is going to look at them very curiously as they asked, why wouldn't you do that? All right, next. Okay, some companies will give you a voluntary appeal. You can do it if you choose to. Some, they're allowed to require 2 levels of appeal. If it's in your policy that you must follow 2 levels of appeal, once again, it's mandatory, you have to do it. You can also call the Department of Insurance. That and $5 might get you a cup of coffee at Starbucks. The departments of insurance are there to deal with massive problems, typically not individual problems. They're not going to be very helpful to you. They're probably just going to say, call a lawyer. And that's what leads you to litigation. Next. Okay, that's the end of my slideshow. Now, I am happy to answer any questions. I don't have a great deal of time. I mean, I have all the time I need, but I don't know how much time we can spend. But the information on here, my firm we make a living doing this, but we are dedicated to helping people. If anybody out there has a particular need for assistance or for just information, and they can call my office and they will receive a response. They will have their questions answered. They will have their questions answered without a charge. We can't represent people without a charge, but we will respond to any kind of questions.